the en banc panel of the Commonwealth Court, July, I think it's 26th of 2012.
Yes.
Zoning is an extension of the concept of a public nuisance which protects property owners from activities that interfere with the use and enjoyment of their property.
Yes.
Do you agree with that?
Yes.
And then it quotes from the U.S. Supreme Court for the proposition that land use restrictions designate districts in which only compatible uses are allowed and incompatible uses are excluded. You agree with that?
Yes.
And
I agree, that's what it says.
That's
Mandel says, that's what he says.
And you agree that that's an accurate statement of the law?
I think that's simplistic. It's not incorrect, but it's more complicated than that.
Well,
That's a starting point.
And it goes on, doesn't it?
It does.
Land use restrictions aim to prevent problems caused by the pig in the parlor instead of the barnyard.
Yes. Right? Yes. That was the keystone of that, and I believe that emanated from Mr. Kamen.
It did. What's the theory there?
It's a layman's way of stating exactly what was stated previously. You try to keep compatible uses compatible. You try to make things as compatible as you can.
So contrary to what you were saying earlier, you're separating compatible uses from incompatible uses, correct?
No, I don't think, to say that you're not putting the pig in the parlor doesn't mean that you totally separate agricultural uses from residential uses.
Right.
That's the point.
It's about compatibility.
It is compatibility.
And discussing that further, it said reserving land for single-family residences preserves the character of neighbors, securing zones where family values, youth values, and the blessings of quiet seclusion and clean air make the area a sanctuary for people. And that's quoting from the U.S. Supreme Court going back to 1974. It's a well-established concept, right?
That's right.
And then if you go down to after the footnote, paragraph beginning, so there is not a pig in the parlor instead of the barnyard, zoning classifications contained in zoning ordinances are based on a planning process with public input and hearings. And it goes on, the MPC, that's the Municipalities Planning Code, correct?
Yes.
Requires that every municipality adopt a comprehensive plan, which among other things includes a land use plan on how various areas of the community are to be used. Correct? That's section 301 of the MPC.
Yes.
Down on to the next paragraph. And you agree so far?
Yes.
I
I agree, that's what the township did here.
And you agree then with the sentences at the bottom of the next paragraph. Zoning ordinances segregate industrial districts from residential districts, and there is segregation of noises and odors necessarily incident to the operation of industry from those sections in which the homes are located. You agree?
Yes, that's what the township did through Ordinance 127.
Each piece of property pays in the form of reasonable regulation of its use for the protection that the plan gives to all property lying within the boundaries of the plan. Correct?
Yes.
Now, the discussion goes on now to the concept that zoning is based on, and there's a Latin phrase that stands for the concept that you use your property as not to injure your neighbors. Correct?
Yes.
A property owner is obliged to utilize his property in a manner that will not harm others in the use of their property. And zoning ordinances may validly protect the interest of neighboring property owners from harm. And that's quoting from the Reeland Valley Forge case that we cited to earlier, correct?
I always thought it was Reallen, but I don't know.
And you may be right. I'm bad at pronunciation. Now this next paragraph gets to that balancing stuff you were talking about. It's not proper to zone based on just one set of interests, correct?
Yes, that's correct.
And it's not proper to zone just because you want one set of property owners to benefit, rather than taking the interest of the community as a whole.
That's correct.
And so, we have to look here, as the court said, that under the standard for zoning to be constitutional, it must be directed toward the community as a whole, concerned with public interest generally, and justified by a balancing of community costs and benefits. These considerations have been summarized as requiring that zoning be in conformance with a comprehensive plan for growth and development of the community, end quote, correct?
Yes.
And you recognize that as a truism, don't you?
That's
Accurate
consistent.
statement of the law.
It is.
And then if you go on to the next, well, at least on my copy, it's the next page. The public interest in zoning is in the development and use of land in a manner consistent with local demographic and environmental concerns, correct?
Yes, local.
And now it discusses section 3304. That was the section of Act 13 that mandated oil and gas development in every zoning district, correct?
That's correct.
And it says 3304 requires zoning amendments. So it requires amendments, quote, that must be normally justified on the basis that they are in accordance with the comprehensive plan, not to promote oil and gas operations that are incompatible with the uses by people who have made investment decisions regarding businesses and homes on the assurance that the zoning district would be developed in accordance with comprehensive plan and would only allow compatible uses, correct?
That's what it says.
And that's an accurate statement of the law, isn't it?
No, I don't agree that there was a requirement for a zoning amendment. I believe that they had to be permitted in those districts.
That's the part you disagree about, is you don't think that Act 13 required municipalities to change their zoning?
That's right. I believe they're required you to allow it in those districts regardless of your ordinance. Or to amend it. It's consistent with it.
But you agree with that this is a statement of the law, what's
Yes.
provided in this opinion?
It is.
And the court then, and this is in footnote 21, discussed that what that section, what 3304 did, was that it would classify oil and gas operations as a pig in the parlor. Whether you think of it as a pig in the parlor or a rose bush in a wheat field, it, quote, nonetheless constitutes an unconstitutional spot use, correct?
That's what it says.
And that was the decision of the Commonwealth Court, and that's the controlling law of the land at this point, correct?
Yes.
And had you ever heard the term spot use before this decision?
Yes.
And it's a recognition that if you are putting a use in where it doesn't belong, that you're doing something wrong, in a very general way, right?
It should be characterized, all spot uses aren't illegal. The inference there is that because it's a spot use, it's necessarily illegal, but I believe the reference was that that's an improper spot. But spots can definitely be legal.
And what is a spot use?
Pardon me?
Define a spot use.
Well, a spot use is an area, and it's typically an island, that's the courts call it, that's zoned and treated differently from zoning purposes.
Isn't that, that's different from a spot use, isn't it? Isn't that a spot zone? That's where you zone a different area? He's talking about a use here.
Yeah, because there's not zoning that's allowing this. This is a legislatively mandated use.
Putting it in zones that didn't contemplate that type of use, correct?
Yes, I believe, it's probably paraphrasing it, but what the court's finding is that the legislature required municipalities to create spot zones, illegal spot zones. If you read that they had to make zoning amendments, that's the only thing you can infer.
And the court said that, quote, section 3304, quote, violates substantive due process because it does not protect the interest of neighboring property owners from harm, alters the character of neighborhoods, and makes irrational classifications. Irrational because it requires requires municipalities to allow all zones, drilling operations and impoundments, gas compressor stations, storage and use of explosives in all zoning districts, correct?
Yes.
3304, quote, is a requirement that zoning ordinances be amended in violation of the basic precept that, quote, land use restrictions designate districts in which only compatible uses are allowed and incompatible uses are excluded, and end quote, and it's quoting from City of Edmonds, a U.S. Supreme Court case, correct?
Yes.
And then it says, if a municipality cannot constitutionally include allowing oil and gas operations, it is no more constitutional just because the Commonwealth requires that it be done, correct?
Yes.
And so the Commonwealth Court was finding that it's unconstitutional, just like it would be for a municipality, for the Commonwealth to be putting this use in all these residential and agriculture and other districts around the state, correct?
No. No. This is a mandate that it be permitted in every zoning classification in every municipality.
Right. And the court said,
Can't do that.
can't do that.
Each municipality has to look at its own municipality.
But it also says municipality cannot constitutionally include oil and gas operations. It's no more constitutional for the Commonwealth to do it. The court found that it's unconstitutional no matter who's doing it, correct?
You could have, and I...
Am I correct, sir?
No, you're not correct. And even under this decision, and I'm not saying, this is the ultimate conclusion, obviously, and I'm not saying Middlesex is this municipality. You could have a municipality that, because of its comprehensive plan and how it's been developed, that you would have no pigs in the parlor. You could have it in every zoning classification, potentially, depending on the municipality.
And depending on the regulations that you go along with it.
That's right.
You do a lot of stuff in the zoning ordinance besides simply identifying locations, correct?
Yes.
All right, well, we'll come back to that then. I want to just wrap up this. If you go to the end of that section B, this is in footnote 23. And this is where the court's explaining, sir, what we were talking about a moment ago, about the difference between spot zoning
Yes.
and a spot use, okay? Says, while in spot zoning, the land is classified in a way that is incompatible with the classifications of the surrounding land, the same unconstitutionality infirmity exists here. What we have under Act 13 is a spot use, where oil and gas uses are singled out for different treatment that is incompatible with other surrounding permitted uses. What the dissent ignores is that the sanctioning of bad planning renders the affected local zoning ordinances unconstitutionally irrational, correct?
Yes.
And that's the law of the land, correct?